Hi, I'm Maria-Fernanda Acevedo, Scientific Coordinator of the Cyberjustice Laboratory at the University of Montreal. Thank you for joining today's web conference. For today's webinar, Participant Experience of Virtual Courts, Findings from the UK Video Hearings Project, we welcome Meredith Rossner, Professor of Criminology from the Australian National University. Meredith, over to you.
Thanks. Okay, Maria, can you see the, yeah, great, okay. So thanks, thanks for having me. It's great to not see everyone today, and especially thank you to the folks at the Cyberjustice Lab for inviting me down. I think in the audience today, there are a number of academics and also legal practitioners, so I really hope that we can get a good discussion going. In this talk, I'll talk about virtual courts, but I'm going to end it on a question about sort of what the next steps are. So hopefully we can get a good discussion going around the future of courts. So this is a familiar format for many of you, looking at a box on a screen. And today I'm going to have a deep dive into another example of communicating through boxes on screens, which is something that we're all intimately familiar with now. So what I want to do in the talk today is introduce the concept of virtual courts or video courts and canvass some of the research that's been going on in this area that's been taking place long before the pandemic. I'll then discuss the most recent empirical project that I've been doing on this, which has been a qualitative evaluation for the UK Ministry of Justice. And again, this was research that was taking place before COVID. They were piloting fully virtual courts. This became, kind of the front of their sort of portfolio once the pandemic hit, and that's been really exciting. And then I want to conclude with a short discussion about some of the issues that have been raised by this research and what the next steps might be for virtual courts. I should preface here that I'm not a lawyer or a law academic. I'm a sociologist and a criminologist, and I come at the study of virtual courts from that perspective. So from the I approach this from a sociologist who's particularly interested in ritual and emotions and kind of the ritual dynamics of the justice experience and justice process. And prior to doing research on virtual courts, I've done a lot of research on court procedure, on interactions, on the microdynamics of how people interact in court, and on court architecture. And a lot of that informs my approach to the study of virtual courts. So I just want to make sure that we're all on the same page with what we're talking about when we talk about virtual courts. It means a lot of different things to a lot of different people. And so I thought it would be useful for this talk to specify what I exactly mean here. So I'll first bracket or first kind of highlight that I'm focusing on synchronous justice processes. Okay, so that's normally what happens inside a courtroom. Many of you are familiar with other ways that courts are moving online. So for instance, asynchronous processes that are, the kind of large growth of ODR, again, happening long before the pandemic, which is, largely taking place in the civil justice world. You also see a big movement that the Cyberjustice group are involved in with digitizing the paper-based system, right, which is a relatively uncontroversial but very technologically challenging process. But the world of asynchronous justice processes and the world of kind of digitizing case files is not the world that I'm talking about today. I'm talking about the world of the use of video in court for a synchronous justice hearing, so for a traditional court hearing. Now, many of you will know, and many of you will have experienced this, that courts have been using video links for many years, for many decades at this point, in a synchronous format. And I refer to the traditional use of video in court as video-enabled hearings. So that's a type of hearing, that perhaps would have happened pre-pandemic, where most participants are co-located in a courtroom. So the judge, counsel, witnesses, and one person appears remotely. Okay, so you have one person coming in via video link. So this is commonly used in criminal trials with child or vulnerable witnesses, expert witnesses, and has increasingly in recent years been used with defendants from custody or for bail hearings, preliminary matters, and for sentencings. It's also very common to have video-enabled hearings in immigration and asylum cases with people taking part from immigration detention. A virtual hearing or a video hearing is something different. This is a hearing where all participants are remote and meet in a shared virtual space. Okay, so sociologist Christiane Lecoq refers to this as a distributed courtroom, okay, where all participants are remote. So that's kind of what we're doing here today, right? There is no conference room, there is no seminar room, we're all meeting in a virtual space. So participants are in, this is what courts looked like during lockdown, right? Virtual courts during when courts moved online during the pandemic. The judge might be sitting in a courtroom, and judges often were sitting in empty courtrooms, but all of the other players are remote, and the courtroom itself isn't really a staging ground anymore. The staging ground is the virtual space. There is the third kind of virtual hearing, which I'm not going to talk about today, but I'm just going to gesture at because I'm doing a little bit of research in this area. But it's called an immersive virtual hearing. And so this is when participants are actually embedded in a virtual court environment for their hearing. So this is kind of like a 3D kind of VR simulation where actually designers design a courtroom, a virtual courtroom, and users are actually embedded in that court. So that kind of mixes the materials of a courtroom, but moves it into a virtual space. This is a proof of concept that my colleague David Tate and I have developed, and in the next few years, we're hoping to test this further. Okay, so this video-enabled hearing, so the traditional hearing where most people are co-located in a court and one party is participant, the overwhelming majority of research is focused on video-enabled hearings because that was the primary mode of video justice for many decades. This research focuses, the past research in this area has been largely critical, and it tends to focus either on the impact of hearing remotely on judicial decision-making or on kind of procedural fairness, procedural justice. So just some examples of research from this area. In 2010, the UK Ministry of Justice did an evaluation of remote defendants who were appearing in bail hearings from the custody suite. They found that defendants appearing from police custody, bail hearings and preliminary hearings, defendants appearing from police custody were more likely to plead guilty and more likely to receive custodial sentences. But this finding was also a bit confounded. It's really hard to get kind of pure experimental data here because people who were in custody were also less likely to have legal representation. Okay, so that's probably what was driving these findings. A really notable finding comes from 2015 immigration deportation cases in the USA. And these were asylum seekers in the US, and Ingrid Eagley, a sociologist in California, found that they were much more likely to be deported when they appeared in court remotely. And digging a bit deeper into that data, Eagley found that people who appeared, this wasn't necessarily because, it wasn't because on the merits of their case, it was because people who appeared remotely expressed what she called a depressed engagement with the actual hearing. When she interviewed asylum seekers who appeared remotely, they reported that they found video hearings, that they had depressed engagement because they found video hearings to be unfair, illegitimate, there's too many technology challenges that can lead to a lower quality interaction, and that the public was excluded. In 2010, Chicago experimented with remote bail hearings, and indeed, they actually stopped this due to the very large discrepancy in judicial decision-making in terms of defendants who were appearing remotely much less likely to be granted bail compared to defendants who were appearing in person. Now, all of those examples were for defendants appearing in custody, defendants and immigration and asylum cases, people appearing from detention at early stages of a hearing. But note that there's also a large body of research about child witnesses, vulnerable witnesses, and to some lesser extent, expert witnesses. And that research finds no impact of video in terms of jury decision-making or judicial decision-making. So there's also a body of research about how appearing remotely impacts the legitimacy of a hearing or the procedural justice. So Jenny Ward in the UK has importantly pointed the danger of moving a supposedly impartial hearing into what she calls coercive environments, such as a police station or a prison. Carolyn McKay in Australia has done some really interesting work about the soundscape and what a prison sounds like compared to what a court sounds like, and the inherent, kind of by definition, incompatibility of having the sounds of a prison in an impartial hearing, in the sounds of a courtroom. And the sound of a prison, for many of you who've been to a prison or who have heard someone appearing from prison in a courtroom is inescapable, right? So to sort of summarize this research, and Wallace and colleagues have kind of pointed out that it's quite interesting, the rise of video justice, the increasing use of video-enabled justice for vulnerable people such as defendants and asylum seekers. And in fact, it's rather striking that on the one hand, in criminal justice, you have the rise of restorative justice, of problem-solving courts, of therapeutic jurisprudence, and yet at the same time, you have what they refer to as these profoundly depersonalizing innovations, such as the increased use of video. So I want to kind of interrogate that right now and ask whether or not video hearings by definition have to be profoundly depersonalizing, or whether or not there's ways we can think about improving them. Now, note that many have been working for a number of years, including myself and my colleague David Tate, at how we can improve the quality of remote hearings or video-enabled hearings. And the kind of approach that we've always taken is that there's two elements to a successful video-enabled hearing. That's both the technology and the ritual, the procedure, okay? And that's a theme that's going to run throughout the talk today and run throughout all of my research. And so it's important to improve the technology. It's important to make sure that everyone can see and hear each other and that you have high quality technology, but it's also equally important to reimagine, redesign, rethink the way you actually interact the procedure, right? And I'll come to that a bit more when I talk about the findings from this study, but a lot of that means that in practice that a judge needs to change how they interact in the courtroom. And that's perhaps a hard pill to swallow for many. So under experimental conditions in a simulated trial, we found that improving both the design, the technology, and the procedure of the remote witness suite improves the experience for both witnesses and lay assessors, and also enhances the credibility of remote witnesses. More recently, in a study of a distributed court, we found that developing a technological configuration with a sort of immersive style technology in the courtroom and high quality, kind of high tech staging in terms of lighting, audio quality, multi-directional sound, and so on, can actually improve the sense of presence for witnesses who are appearing remotely, and for mock jurors who are watching witnesses and defendants appear remotely, and also that appearing remotely doesn't influence the decision making. Okay, so the defendants who appear remotely are no worse off if they appear in this more immersive distributed environment. And yet, even so, you might ask, improving the technology can only take us so far. So there's a review of the critical literature in this area points to a deeper worry about justice being carried out online, that it's never going to be the same. It's never going to be as good as kind of traditional court hearings. And I think this has to do with a certain veneration of long held ideals, right? And a commitment to a very certain, very specific kind of ritual action. We have very specific ideas about what a court is supposed to look and feel like. So Emma Rowden, in her interviews with judicial officers who preside over video-enabled hearings, points to many judges talking about a sense of loss that they feel is happening with the move to video. Linda Mulcahy, in her book on court architecture and court design, in her discussion of video hearings, argues that even with the inadequacies of adversarial adjudication, there may continue to be some design ideals enshrined in court practice which we want to retain in a technological age. So we're in danger of forgetting that requiring the physical presence of people in a special building continues to have considerable cultural resonance. And so that quote, I think, really encapsulates a lot of this worry that people have, this kind of feeling that there's something not right about moving a kind of democratic, a civic, a participatory practice, which on the one hand is meant to be an act of democratic practice, but also an act of state authority and state power that doesn't work online. Hazel Genn, in a major lecture in the UK about the move to online courts, worries about the loss of physical presence for a range of reasons, and ultimately I'm concerned about the long-term consequences of court merely as a service rather than as a public physical site of justice. Okay, so as Emma Rowden titles it in her book, in her article on this, what do we lose when we lose the courthouse? And what these scholars are arguing is that even when you can have the fanciest technology you can imagine, you're still losing something. So I would have one response to this, and I'm very sympathetic to this argument, and yet to the argument that these critical scholars posit, but I also think it's important to take a step back and remind ourselves what actually happens inside a courtroom, and perhaps warn us against fetishizing courts. Many kind of court architects, architecture scholars, legal scholars sort of venerate courts as these kind of heavy and strong and powerful and meaningful symbols of kind of legitimacy and democratic practice. But the reality is perhaps a bit different for most people who enter into most courts around the world. One reading, for instance, of the history of court architecture, the history of adversarialism, is the history of the exclusion of lay people from the center and the privileging of professional knowledges, of legal knowledges and of judicial knowledges. Indeed, there's a very long tradition in criminology, in socio-legal studies, demonstrating all of the ways that going to court for most people, perhaps not for lawyers or for judges, but for everyone else, is confusing, is degrading, is alienating, is stigmatizing, is not necessarily, it doesn't necessarily fill you with these kind of holy ideals that we think of that the court architects think about. In a paper a couple of years ago with some colleagues, we did a study of court architecture, particularly about the placement of the accused in a dock in the courtroom. And we found that the placement of the accused in a dock, and increasingly in a secure dock, so in a glass box in a courtroom, has a significant and consistent prejudicial impact. So mock jurors in our study were much more likely to find a defendant guilty when he appeared in a dock, in a physical dock, compared to co-located with his lawyer in the courtroom. So Emily Brissett in the US has written about in arraignment hearings. She's identified them as a kind of form of epistemic violence that's embedded in routine everyday court practices. In the civil realm, Hazel Genn has written about the great lengths which most people who have civil disputes go to avoid the law because it's so confusing and hard to understand and disempowering. So I would argue that you don't necessarily want to recreate what happens in a courtroom, in a traditional court, in a video space. And that's a theme that I'll return to at the end of this talk. I might also add to this that the structure, that all of that research on video-enabled hearings that I canvassed in the earlier slides, again, is about video-enabled hearings. So it's about everyone co-located in a courtroom and one person appearing remotely. I would argue that the structure of a virtual hearing where everyone appears remotely is distinctly different in the way it looks, the way it feels, the way it's experienced by people. And in fact, you can't extrapolate from research findings about video-enabled hearings to findings about fully virtual hearings. Okay, so what happened during COVID? This, again, should be something that most of you are very familiar with. You will know that all over the world, For example, jury trials were suspended and almost all other matters were moved online, including in many jurisdictions, such as mine in Australia, judge-alone trials. So trials that would have normally been held by a jury were held by judge only. And in fact, ACT, the jurisdiction where I live, the Australian Capital Territory, actually suspended the right to trial by jury for a brief period during lockdown. The federal court in Australia, where I'm based, moved online very early, in the kind of early part of March. This made sense because they were already a very high-tech court that was conducting a lot of business online, and all other courts soon followed. This was kind of well documented in the legal press as sort of an overnight shift in terms of how legal professionals, members of the judiciary, members of the legal profession, kind of their attitude towards video courts, towards virtual courts, kind of shifted overnight, partially, out of necessity, right? It certainly was a requirement, but I would say that for the most part, there was kind of a very large, almost overnight sort of shift and large, for the most part, acceptance of the need to have most court hearings in a virtual format. This image that I put here for you is just a particularly, I think, compelling one. This is from the UK Supreme Court. This was a swearing in of Lord Legat, so a new Supreme Court justice. He was sworn in remotely via Zoom. So this is him in the UK Supreme Court by himself, being sworn in by his fellow justices. And there have been a lot of hiccups, both non-serious and more serious, during this period. But I would say that it, for the most part, it kind of largely sort of worked. Now, this may be the case of not letting the perfect be the enemy of the good, but courts, for the most part, got through their lists. Judicial decisions were made, were handed down. I did some interviews with some appellate court judges in the US and Australia. This was probably a bit easier in the higher courts, in the Court of Appeal, because judges were already quite used to sort of working remotely, and most of these cases were, the paperwork was much more heavily involved, so it was a bit easier. At the lower courts, it was harder, but for the most part, it worked. So different jurisdictions in Australia all very quickly developed their own sort of virtual courtrooms, same in the UK. The exception to this is the criminal jury trial, where we are still attempting to deal with the backlog of cases that have been put on hold and the people who are still in custody waiting trial. So I'm going to bracket the issue of the criminal jury trial, and return to it at the end of this talk. So, there was a few kind of like funny sort of hiccups, and here's some example. You may remember that the US Supreme Court, for the first time ever, heard a case remotely over the telephone, and there was the mystery of the toilet flushing during oral argument. We don't know where it came from. There was, headlines around judges remanding lawyers for not wearing trousers during hearings, and so on. And that's kind of funny, right? But there was also, some more seriously troubling things that happened during this period, which would raise questions about due process, about the protection of rights, and particularly about open justice. And so those are some of the kind of key ongoing issues that I'll return to later in this talk. Okay, so this takes me to where, to this current research, this 2020 process evaluation of video hearings in the UK. I am now based in Australia, but prior to that, I was at the London School of Economics, where I was the independent evaluator for the UK Ministry of Justice trial of fully video hearings. So what happened was in 2016, 2017, a team at the Ministry of Justice decided that they wanted to pilot a fully virtual hearing. So not a video-enabled hearing, but a fully virtual hearing where all parties take place remotely. This started in the tax tribunal, So that would be hearings that were party to state, so the appellant and the tax office. And we did a project, an evaluation, a qualitative evaluation of that pilot in 2018. And then they expanded to slightly more complex cases in civil and family court. And that's what the evaluation that I'm talking about today that we published in 2020. So these, again, were for relatively straightforward and perhaps uncontroversial hearings where evidence wasn't necessarily tested in open court, where it was not necessarily very complex cases. In civil courts, these were set-aside judgments, so people who had a county court ruling against them petitioned to the court to have that ruling set aside. First directions appointments in the family court, which were kind of early hearings to do with financial remedy in early stages of divorce. Also emergency injunctions. So these were mostly women who were seeking protection, emergency protection orders in the civil court, and then also basic tax appeals in the tax tribunal. Okay, so that's a wide variety of types of cases, but they're also pretty representative of the types of business that happens in the court, right? So I'll say here that this research was done before COVID, although it kind of overlapped a bit the tail end of it. And these particular hearings were not part of the UK's COVID response, but early testing of the product that was used for this pilot helped to inform what the UK calls the CVP virtual courtroom. That's the Kindly Cloud virtual platform, yeah, which was rolled out across England and Wales. So that's the product that England and Wales used during COVID. And the early version of this product is what we're testing here, what we're examining here. So just to give you an idea of what that actually looks like, this is something that you would all be very familiar with. We've all, engaged in countless meetings that look just like this meeting right now, where you have, this is the participant view. So on the left, you have the judge. On the right, you have the opposing party, and you have self view in the bottom. This is what a judge would see. Again, you'd see the two parties side by side, and then you would see yourself. The judge would see him or herself in the bottom, again with the option of hiding self view. I'll analyze this more a bit later on. I just wanted to give you a view of what these courts actually ended up looking like in practice. So we anticipated a relatively low sample. These were a kind of small number of cases coming through. These were two courts. This was the Manchester Civil Justice Centre and the Birmingham Civil Justice Centre. Sorry, three courts, and then the tax tribunal, which was based in London. And our methodology was qualitative, and that it focused largely on observations of video hearings where we sat in court with the judge. So the judge sat alone in an open court, and this was because they needed to satisfy the requirement of open justice. I will note, and this will be familiar to many people who've done research in courts, throughout the entire length of our research, I think there was no one in the public gallery aside from us as the researchers. We took open-ended field notes, and they were thematically coded, and then we did a series of semi-structured interviews with all of the stakeholders that we could interview. So that includes the judges, the legal representatives when there were representatives, litigants, appellants, defendants, the team, the video hearings team who helped put this together, the administrative staff, the support staff. Ultimately, it resulted in 40 observations of hearings and 69 interviews with stakeholders. Okay, so this is a very lovely diagram that was developed by the Ministry of Justice to describe how these complex hearings, and I think what this diagram demonstrates is all the work that goes into creating that screen that you saw a couple of slides ago. So there's a lot of work that's involved kind of before the day, both in terms of kind of the scheduling, the setting up of a hearing, the kind of gaining consent, the kind of managing, both getting two parties to take part in a hearing, the suitability checks, the communication, all of the preparing technology, testing people's technology, all of that. And then on the day of the hearing, there's sort of a final important element to that journey, which is the kind of technology checks in the hours and minutes before, and then of course the waiting room, and then the actual hearing itself. What I'm going to focus on today is the preparation bit, okay, and then a little bit on the hearing itself. So what was so important, what came out again and again in our research, in all of the interviews that we did, and I say we, this was done with a PhD student, Martha McCurdy from the London School of Economics. What we found again and again was that the preparation was vital, especially with lay participants, with self-represented litigants. What happened was once their hearing was scheduled as a video hearing, they would take part in a telephone call with a video hearing support officer. And what that video hearing support officer did was test their technology with them. So would do an internet speed test, would get them to log into their program. It was a web-based platform. They would trial out that platform, and then the hearings administrative officer would offer some advice about appearance, basically, about how to have a suitable space, kind of whether or not their background was too busy, whether or not they had a shadow on them. And also suitable dress. Everyone we spoke to gave very, very, very positive feedback about this, that it helped to reduce their anxiety, it helped them to prepare, it helped them to feel more comfortable in the video hearing format. Here's some quotes from some of the people we interviewed. It was very useful to be provided with this reassurance about what would actually happen on a day. And note here that this is something that most people who go to kind of traditional court, they don't get this, right? They don't get, a phone call from someone at the court telling them what it's going to be like on the day, or giving them the chance to kind of have a dry run, right? So I would say this is actually a significant improvement over kind of traditional court practice. At the same time, this is almost impossible to scale up, right? This, I suspected, this level of support was not available during COVID, where every single case was moved online. And indeed, when we were finishing this project, they were already transitioning away from kind of one-on-one phone calls to an automated system where a user would kind of log on and to an automated check, where they would be kind of given a checklist about their internet speed test, testing their microphone, testing their video, and some kind of general advice about court etiquette. We weren't able, unfortunately, to evaluate that. I wish that they would have extended the project so we could have, but I think that significantly impacts the kind of human to human preparation, made the virtual interaction so much better particularly for the lay participants. Legal participants less so, because they were it was many of the same solicitors who were kind of regularly appearing before a judge, and they sort of knew the script already, right? They were quite comfortable in a courtroom, or quite comfortable talking to a judge. They would generally engage in kind of a training session or an information session with someone from the video hearings team, and they were kind of overwhelmingly positive about very quickly adapting to the virtual format. So what would happen is that all users would log on to the hearing on the day, and they would enter this waiting room. So this was a very self-conscious attempt by the designers. And I should note that the designers, they spent like a year and a half designing this before we even came in as evaluators. They worked with designers, with kind of color experts, with behavioral economists. They consulted on a range. They did a lot of kind of laboratory testing for kind of usability, for readability, for access for people with disabilities, people with trouble reading, people with kind of a range of different issues. And what they were attempting to do was recreate what they call the journey to a courtroom. And so what that journey looks like when you translate it virtually is that users click through a series of screens that remind them that this is a formal court, some information about court etiquette, and then they wait in the room that you see before you for the hearing to begin. They're kept in, there's a administrator who is kind of managing the hearing, kind of like Maria is here, right? Making sure there's no technological difficulties, keeping in touch with the different parties if things go wrong. You can see, you'll be able to see if the other parties are logged in, the name of the judge, and so on. And when the judge is ready for the hearing to begin, they hit a 60-second countdown timer, and then that timer appears on everyone's screen. And then when the timer counts down to 0, everyone becomes visible on the screen, and the hearing begins. So in the actual hearing room, note here, there was a significant preoccupation, and this is something that is I have also found in my interviews with Court of Appeal judges during COVID, a preoccupation with making sure that the coat of arms was visible, because that was something that they were grasping at to have some symbols, some really important traditional symbols of the court. So much so that in some of the civil court hearings, for the hearings, the emergency injunction hearings, those were actually not held in a courtroom because those were private hearings. Those were held in the judicial library, but they physically brought in a coat of arms and hung it behind the judge so that kind of turned it into a courtroom. There was an issue in the tax tribunal because the tribunal didn't just have a judge, but also had tribunal members, right? Tax experts sitting with the judge. But it was designed, but the screen you could only see the judge. So there was no space for the tribunal member to appear on screen. That created a problem. Judges were unsure what to do. So sometimes judges just took up the center of the screen. Other times they might scoot over and invite the expert onto the screen. Other times, only when they wanted to consult the expert would they invite them onto the screen. All appellants of both self-represented litigants in the family court and civil court, all kind of dressed appropriately, I guess, appeared in smart or smart casual attire. Everyone followed the instructions, had kind of plain backgrounds. So, plain or light colored walls. The lighting was pretty high quality. There was a difference in terms of some people were clearly appearing from kind of mobile devices. So all you could see was kind of close-ups of their face, whereas other people kind of had, I guess, higher quality framing, were appearing at a desktop computer like I am, where you could kind of see someone's kind of head and torso. Legal representatives, many of them were appearing from conference rooms, which was sometimes problematic because you could see them sitting at a very long table in an empty room by themselves, and the camera was on the other side of the room, so they actually would appear quite small. There was kind of a range of ways that people appeared, and I think that if we could give one criticism, the inconsistency in the kind of staging and the sizing and the framing of participants, I think created a problem. So here, this image is not from a real hearing. This was a mock-up supplied by HMCTS. So those are actually staff members of the video hearings team who were playing the roles using the platform, but they didn't necessarily in the actual hearings look so consistent in their image. All of the users we spoke to in these hearings experienced them as more convenient, as saving money, and as saving time. And so note, again, these were in major cities, Manchester, Birmingham, with very kind of large populations that are dispersed. So for many, it would take a long time to get into the Civil Justice Center in central Manchester. With a lack of high quality public transport, you could easily travel 1 to 2 hours to access the court. Many reported that it was much more convenient than actually going to court in Manchester. The tax tribunal is based in London, but the appellants are based all over the country. So, they would have actually had to travel, for a whole day and stay overnight if they wanted to come and present their case to the tax tribunal. It saved time. People reported that it was reduced their anxiety to appear from the comfort of their home. I sat and waited at my laptop, and then it was done in a matter of 10 or 15 minutes. That was one defendant from set-aside judgment. Participants, appellants, defendants didn't have to take as much time off of work, and so they reported that as another positive. Some people actually took part in their hearing from their place of business, from their office. So for instance, here, one of the claimants in set-aside a hearing said that their boss let them have an hour or two out of the office rather than half a day. They actually, in this case, they actually did take part in the hearing from their office, but they were off work for that hour or two. And then importantly, in the emergency injunction hearings, these were the non-molestation orders, women seeking out emergency injunctions after experiencing violence, usually from an intimate partner. We interviewed them and we interviewed their solicitors, and there was consistent feedback. This was really, really positive in terms of both providing access to justice and also providing safety. So these are hearings that happen really quickly. A claim is filed, an application is filed perhaps that morning, has to be filed by 10:30. And traditionally a judge would basically hear that case whenever they could that afternoon. So they'd have to squeeze it in sometimes. These were emergency hearings. And that meant that you would file an application by 10:30, you'd have to go to court, be at court by 12, and then you would sit at court all day, all afternoon, until the judge had space in their schedule for a hearing. And that, obviously took up all of the solicitor's time, but also took up all of the time of the applicants, many of whom had young children in school or had to take their children with you, had childcare issues. And the ability to go to your solicitor's office, file the application. These hearings were actually scheduled, at a specific time. So the judge would hear all emergency injunction hearings, at 2 p.m. Know that you could come in at 2 p.m., have your hearing. Sitting next to your solicitor in their office was kind of universally seen as a better option than actually coming to court for these types of hearings. The technology was quite high. In our earlier evaluation, we found that the technology broke down a fair bit. That was certainly improved with the upgrade to this sort of web-based system. And this was similar to Zoom or similar to the types of video conferencing software that all of us are very familiar with. There were a few technological issues, but they were resolved quickly, largely by the participants themselves, either restarting the hearing, or repeating what they had to say, or pausing, and so on. When there was more significant technological hearings, participants were kept informed by the administrative team. The video was always fine. There was many instances of poor quality, and that was usually when people didn't have their own microphone. So that was one of our recommendations, that people have a high quality microphone. So just an example here, this was from one of the cases that we observed. In that case, the defendant, in a set-aside judgment, his face actually was frozen on the screen, and the judge became aware that his face was frozen. He stopped, he asked the defendant if he wanted to proceed. The audio was fine, but his face was frozen. If he wanted to stop the hearing or if he wanted to proceed. And in this case, the defendant said, no, he's happy to proceed even if his face is frozen. And then maybe a few minutes later, his face unfroze. Judges who we interviewed consistently reported that these hearings ran better than they expected. And yet at the same time, they were also more fatiguing. And that's a finding that will be familiar to many of you who've had long Zoom sessions, and what judges in the media have commented on during COVID. So here's one judge in the civil law courts. Video hearings are more intensive. You have to keep one eye and being able to hear and see. In a physical courtroom, people naturally interact. You can see both parties and you can see they have the papers. But dealing remotely, you always feel like there's a bit of a delay and there's a verbal dance trying to wait for one another, and it becomes more disjointed. In our observations, the judges did a fantastic job of managing turn taking and making sure that parties understood. But what's important to note here is that they had some training about what's different about managing a hearing virtually compared to physically, and you could see that they use that in practice. So the judges, it took longer, these hearings, because they spent a lot more time at the beginning introducing parties, making sure that they explained how the hearing would go. This was the case for self-represented litigants, not so much when it was just lawyers in the room. Consistently referring to people by name, consistently pausing to summarize what had happened so far and what will happen next. And it's important to note that we observed a sample of traditional in-person hearings, and also just in my experience of sitting in court for many years observing hearings, that's not normally what happens in court, right? The judge doesn't normally slow down necessarily to make sure everyone's understanding what's going on. So that was a departure from normal practice, and that's a departure that people responded really positively to. So just an example from one of the defendants in a set-aside judgment. we asked about what happened with how the judge managed their hearing. And what you see him describing here is the judge taking ownership of it all, and actually you can managing turn-taking rules. He would ask me a question, then he'd ask the other lady a question, and yeah, everyone knew who was who, right? So the judge was able to make sure that everyone knew whose turn it was to speak and when. I'm going to end in a few minutes because I want to make sure there's some time for discussion, but I just want to briefly pause on this discussion, this important issue, back to the critique that that many of the scholars were pointing to earlier in the discussion around the ritual. And I think that there's a consistent worry that the authority of the court is undermined when a judge appears remotely. And that that video hearings are less formal than traditional hearings. And so this is something that we really spend a lot of time talking to people about. And so, for instance, this is the judge in starting a hearing. This is an example of how they would sort of demonstrate authority. You should see the coat of arms behind me. This is to remind you that this is a formal hearing and the same rules apply. And then he goes on to give some of the rules. A judge remarked to us prior to a hearing, to the researcher in the room, I suppose that their front room, so the appellant's front room, is an extension of the courtroom, and I take control of their room like I do the courtroom. Okay, so here the judge is actually seeing, is actually envisioning the party's living room, the party's room physically becomes a courtroom for the duration of the hearing. So there's a lot of preoccupation on behalf of the judges that that authority be respected and that the formality of the court be retained. In our observations, the parties appeared to respect that formality of the court. Everyone used the appropriate language. There was no eating, there was no drinking, there was no acting inappropriately. And yet judges expressed again and again worries about this. So for example, when you get people on video in people's living room, people's kitchen, it is always inevitable that things happen. The judge, goes on to say that people naturally being in their house is a different dynamic than being in the courtroom, and the everyday mill of life carries on around them. So that was a general worry that judges had. And note that we interviewed them at the very beginning of the pilot before they'd actually done any hearings, and then again at the very end after they'd had experience doing a number of virtual hearings, and their opinion didn't change. And I point this out because we never saw this actually happen. You never saw people appearing in their kitchens with kind of busy life happening around them, or the everyday mill of life carrying on. People actually, for the most part, did have a private room that was quiet, that was secure, that they reported to be safe, and yet this fear remains that video hearings are not as formal. Legal professionals uniformly thought that it was no different than appearing in court. It was the same judge, same responses that we always get. It was just like being there in person. I was surprised at how much like a face-to-face hearing it was. These hearings were much shorter, and they were procedural, and they were over very quickly. The lay participants that we interviewed agreed that perhaps it was less formal in some ways, but that's not necessarily a bad thing. So they pointed to the fact that it was perhaps more comfortable. It was a bit less formal, but that made it less stressful. But I think this final quote from one of our participants is actually the most important one. He says, it was both formal while being easy enough. It was professional in the best words. So I want to kind of ask you to think about what the difference is between a formal encounter and a professional encounter, and see if that helps us bridge this kind of gap between what we think a physical court should look and feel like, and what we think a virtual court should look and feel like. So just to summarize, in other work, I've been writing about ritual and remote rituals, and I think if I could point here to the kind of what's most distinctive about the virtual ritual that's different from the court, in physical ritual, it's this idea that both the materiality and the symbols of a court are different, right? And also a sense of presence, sense of co-presence is different. It's not necessarily not there, but it takes a different form. In this study, participants clearly benefited from preparation and support. They benefited from being given advice on impression management. This is consistent with some earlier research from the sociology of technology about how comfort with technology helps with a sense of presence, helps people feel like they're present in a video mediated interaction. But there are distinct problems with scalability here, how to scale up that kind of preparation and support. The limitations of the technology, I might argue, can actually force the rituals to be, in some cases, more inclusive. So for instance, the flatness of the design of having everybody appear in the same size box is arguably more democratic or more participatory than having a traditional courtroom with very clearly defined structures of hierarchy and power in terms of the bench and where the lawyers sit and where the lay people sit and where the public sit, or even in a traditional video enabled hearing where everyone's co-located in a courtroom and one person is remote. Participants developed their own strategies to deal with technology problems. So this is what you, again, would all be familiar with. If you couldn't hear someone, you asked them to repeat themselves. If you knew there was a delay, then you were patient and you waited for the lag between audio and video to catch up. As Christian Lecoq and colleagues kind of have written about, we have all become our own sort of directors of a produced video event, and we seamlessly adapt to kind of like glitches in communication to make communication work, to develop a sense of what they call mediated co-presence. Although note here, these examples that I gave before in video enabled hearings, in those in more coercive cases where people are appearing from custody or appearing from immigration detention, you did not, those are not examples of people developing a sense of mediated co-presence or participatory or democratic practice, right? So I wonder if in the future, what we've learned from video hearings can help us actually reimagine courts to be better. I don't think it's necessarily fruitful to replicate what happens in court on a screen. As Richard Susskind says, grafting technology onto a process that can date as far back as 900 years is not the answer. And so you can see that in our research, for example, with this inconsistent interpretation of how formality is communicated and its role in a court hearing, whether or not we actually want hearings to be the same type of formal that we traditionally think of when we think of as a formal hearing, or rather we want to reimagine hearings as a more professional encounter. And the move online also offers us a chance to rethink the symbols of justice, the symbols of the court. So for example, I pointed to the preoccupation with having a coat of arms, which, note, in practice was often obscured by the judge's head anyway, so people couldn't see. And I wonder if, with technology now, with the opportunity to have virtual backgrounds, with the opportunity to have people appearing with a range of different backgrounds. I watched the Court of Appeal cases in California where judges were appearing from chambers, and they had, flowers behind them. They had, traditional law books. Some of them had photographs of themselves and their family members behind them, which raises security issues, but it's still really interesting in terms of thinking about different ways you can display a judge. I just want to give an alternate example of ways that the symbols of a court can be reimagined in a virtual sphere. This is a real court. This is a family court in New Zealand, but it's done away with the coat of arms and replaced it with a tapestry presented by the local Tongan community. And think about whether or not the move online can give us a chance to experiment with alternative symbols of not just state power and the crown, but actually actually symbols of reconciliation and inclusion. So the ongoing issue here is with people appearing from custody and coercive spaces. How can you create a participatory and inclusive environment when people are appearing from prison? There's an issue of access to technology, access to high quality technology. Note in our study, everyone had high quality technology, whether or not it was laptop or mobile, had high speed internet. The group that consistently had poor connection, poor quality internet was actually the tax office. So they were kind of in government buildings using the kind of government internet, and that broke down more often than the people appearing from home. And then I haven't spoken about it in this talk, but it is an issue around open justice and how the public can be involved. So I'm going to end here, but I want to end on a question for you. Is it okay, Maria, if I have one more? Just, yeah. And that's, this question, I've kind of given you the easy case, which is civil courts and to some extent family courts. And I've shown you that the technology and the ritual can be designed to create a suitable alternative to in-person hearings. But the hard case is the case of criminal jury trials. And this is something that I want to kind of open up and see, ask you if the findings that I have found and the ideas I've presented can help us think about what to do here. Many of you know that jury trials were suspended and now they have been reintroduced in a socially distant manner. And what that looks like is what you've seen on the screen here. So that's a jury box where they've put plexiglass between every single juror. Down below, you have that's from the US. Here's a mock-up of a socially distant courtroom where jurors sit in a public gallery with plexiglass kind of arranged around the courtroom. And I ask you if you can think about how that material of glass, plexiglass, and the symbols that carry with it influence the experience of court and the experience of co-presence, and whether or not, if that's what criminal trials are going to look like, whether or not actually we want to think about having a virtual criminal trial and what that. I know that that's something that no one wants to do, but whether or not the idea of having kind of virtual lay people in a complex, serious case like a criminal trial, which has been done in the US for civil jury trials, has been tested in different parts. This is a demonstration of a mock jury trial in the UK, whether or not that is something that is a possible or perhaps even more preferable next step. I'll end it with that.
Thank you, Meredith. So right before we go with the questions from the audience, well, there's currently no questions, so please do not be shy and send in your questions so we can have a bit of a discussion with our speaker today. Here we have one already, but I'll start also with some question I had. I know that one of the concerns that comes up around virtual hearing is the impact of nonverbal communication, which is less perceptible in this kind of hearings. I don't know if you had any findings to share with us. I know that maybe the type of cases you had and the type of hearings you had didn't need so much of nonverbal communications, but I don't know if you have something to say about this.
Yeah, thank you. That's a really good question. So, and I can talk about that in terms of the findings from this study, but also some of the studies I've been doing with David Tate around the distributed courtroom. So I mentioned in the finding that there was this issue around framing, and that some people appeared close up where you just saw their face, and some people appeared, from their waist up, but some people appeared from really far away. And it was consistently clear, and this is consistent with some of the kind of research that that kind of sociologists and linguists have done about virtual courts, is that being able to see someone's arms and torso actually was clearly preferable because of gesture and because of and that kind of enabled you to kind of see body language more and see whether or not someone, how engaged someone was. If someone was appearing from their mobile phone and all you saw was their face, that was harder. And if someone was appearing from really far away where you actually mostly saw the room and only saw them, that was harder. So we did give feedback on that in our recommendations to the MOJ, that they actually needed to be consistent framing, and that's something that needed to be built into the design to make sure that you could see everyone from the waist up, because actually that's how we are used to seeing people when they testify as witnesses and so on. In the distributed court study, this was a study where we brought in pretty high quality technology, so pretty big screens into a courtroom. Made sure we had consistent lighting across all the different parties, made sure that everyone was kind of visible, and that there was high quality audio. We actually found that mock jurors could see people, they reported being able to see the defendant's gestures and also their facial expressions like better when they appeared on video than when they appeared in the doc. And that was actually probably because we took pains to make sure they could. It was built into the design. So I would argue that, like in a criminal doc, or even in many traditional witness boxes, actually it's really hard to see that as well. Yeah.
Yes. And you were also talking about the need to reimagine some of the rituals of the court. And I was thinking about the what about the change in the judge's role itself? Because I know that for the UK project hearing, you had a specific member of the tribunal helping users with any technical difficulties, maybe. But I don't know if that it's possible in every type of virtual hearing. So how the judge needs to approach this new change of role.
Yeah, and that's something that's really important. And that's something that we interview judges about. And I should say that the opinion is divided on it. So many of the judges that we interviewed, felt that that judges needed to, now let's see, how can I say this? So some judges we interviewed thought this is not my role as the judge. So for instance, I don't want to be the one that's like pressing the countdown timer to start the hearing. I don't want to be the one to, I need a clerk, I need an associate. I don't want to be the one to manage technological difficulties. I don't want to have to restart the hearing, but also, it's not my role. And that's a legitimate worry, because judges are worried about like the, they're being asked to do more and more. And it's true that like a lot of the research and surveys about judicial satisfaction with their work has gone down dramatically in the past years, because judges have been asked to do more administrative tasks than they've traditionally been asked to do. At the same time, we also had judges that said, look, this actually is our job, and our job as judicial roles have evolved over the centuries, and they are continuing to evolve. And we actually, it would make the judiciary look bad if we didn't know how to like manage the technology. And so that was like one issue around actually managing the technology. And that was something could be as simple as like pushing the button, right? And there was I've actually sat in on like countless meetings with judicial committees with the Ministry of Justice, with civil service and judges, about whether or not judges should have to press that button to start a hearing. But the second issue I think you raise is not just about managing technology, but managing people, and whether or not it requires a change in how judges do their job. And I would argue that it does, and that it has to, and then it can be a good thing. And that is mostly about making sure that people are able to understand and follow along what's happening. And there requires a lot more active participation on the part of the judge to refer to people by name when you speak to them, to spend a lot of time. It's kind of scaffolding, providing an explanation of what's going to happen at the hearing, pausing multiple times to make sure people understand. And that's not in most kind of lower courts where like cases are processed really quickly, or in trial courts where legal professionals tend to dominate. That doesn't really happen, right? Time isn't normally spent, and that's definitely a shift that judges have, and judges told us that was something that was different about their job. And again, opinions sort of divided, I think, on whether or not they're happy with that. But I think they have to. I think they're going to have to.
And for the last time, I would like to thank you, Meredith, for this presentation. We had a very interesting discussions, and the findings are very interesting for what's to come in the future.